case were never charged with misconduct?
Well, are you talking about Fort Heights 4?
Yes.
It's just probably pretty much unrealistic to think that the Cook County State's Attorney's Office would charge local police with misconduct in a case in which the prosecutor's office misconduct was equally culpable. I think that it's just not, the justice system simply does not do a very good job of investigating and policing itself. And in this case, they certainly did not. But the evidence, I think, of gross misconduct, official misconduct, is so overwhelming that, of course, it led the Cook County Commission to approve a settlements of nearly $40 million for the 5 defendants in the case. No, there's no. But in fact, never in the history of Illinois has a police officer been charged and have been convicted of misconduct in a criminal case. They've been convicted many times of bribery. I mean, there may have been somebody who was convicted for taking a bribe in connection with a criminal case, but certainly not for doing anything that led to a wrongful conviction or a wrongful arrest. It has simply never happened in the history of Illinois.
Yeah, that just seems unfair. Okay. My second question is, well, I know you've written a lot about the Fort Heights 4, but are there other cases that you have worked with that you would like to mention to help me better understand this topic?
There are a number of cases. In fact, I and the Center on Lawful Convictions have been involved one way or another in 60 exonerations. That counts, 14 cases that occurred before we actually founded the center in 1999, and it includes all the cases in which co-defendants were represented by other counsel that our work was instrumental in the ultimate exonerations. The kind of police and prosecutorial misconduct that we saw in the Fort Heights 4 case, of course, is not isolated. It's a quite common phenomenon. There were other factors involved here, of course, a false confession, and I sent you that chart showing how prevalent false confessions are. Most recently, we've had a really fairly dramatic false confession case, and you can look it up on our website, of a young man named Daniel Taylor. If you look at Illinois exonerations, here Daniel spent 20 years in prison for a murder to which he confessed, but he could not have committed because he happened to be in police custody at the time it occurred. That shows that there's clearly something very wrong with the interrogation process. And as that chart I sent you shows, more than half of all of the documented wrongful convictions in Cook County, Illinois, that we know about, involve false confessions, either of the defendant himself or of a co-defendant that implicated that defendant.
False confession. Okay, this next part is a two-part question. So do you think it is fair to say that this case is the main reason of the abolition of the death penalty in Illinois, or are there other equally important factors?
Well, quite frankly, this case, I think, sort of set the movement in motion, and consequently, it was clearly very important ultimately in the abolition of the death penalty. It alone would not have led to abolition of the death penalty, I can assure you. I recently wrote an article about abolition. I may have sent it to you, a Minnesota Law Review article on how and why we abolished the death penalty. Illinois. I don't know if I did, but the fact is that there are just a number of factors that were involved in abolition, and you could see if you withdrew any one of maybe 50 of these, it all would have collapsed. So the Fort Heights 4 case was extremely important, and if we exposed that first in Chicago Lawyer, of which I was the Rolando Cruz and Alejandro Hernandez in DuPage County preceded the Fort Heights 4 exoneration, but the thing that really launched, I'd written about the Fort Heights 4 case long before Cruz and Hernandez, and I think that's what, so it was instrumental. We clearly would not have abolished the death penalty had it not been for that case, and had it not been for that case, for the Fort Heights 4 case, I don't think we would have founded the Center on Wrongful Convictions, and had it not been for the Center on Wrongful Convictions, I can assure you, we would never have abolished the death penalty. I don't know if that answers your question. But, we started the Center on Wrongful Convictions in 1998, or 1999, on the heels of a 1998 conference here at the law school entitled the National Conference on Wrongful Convictions and the Death Knights, and it wouldn't have happened without Anthony Porter, and it wouldn't have happened if we not started the Center on Wrongful Convictions, and it wouldn't have happened if we had not had the right people in place in the legislature and the right governor who was willing to sign it. So there are a lot of factors involved, but I think one very important one was the Fort Heights 4 case.
Okay. And in my research, I found that 2 of the 13 people wrongfully sentenced to the death penalty were from the Fort Heights 4, and the state of Illinois had paid them $36 million. But do you think...
To the Fort Heights 4, they paid $36 million. To the 4 men, got $36 million, and then Paula Gray got an additional $4 million, so the total came to $40 million, and there was also prejudgment interest, so it cost the taxpayers more than $40 million.
Okay, and do you think that avoiding this financial cost was a big part of why the death penalty was abolished, or was it simply because the system was?
I think that the costs were a really important factor in abolishing the death penalty, but more important than this $40 million civil settlement in the Fort Heights 4 case was that in the early 2000s, in fact, the Illinois legislature passed something called the Capital Litigation Trust Fund that would provide additional money for investigating, evidence and mitigation and aggravation in capital cases for both the prosecutors and defense lawyers. Now, in that fund began expending more than $10 million a year, and it spent about $160 million between its establishment in, I think, 2001 and the abolition of the death penalty in 2011. During that period of time, the state of Illinois sentenced only 10 people to death. Now, those funds weren't spent on just those 10 cases. Those funds were spent on a lot of cases in which the death penalty was dropped, or a jury didn't impose it, or something of that sort. But it was clearly just almost unaffordable. And the evidence in aggravation and mitigation, that means aggravation means that there's some reason that this person is really bad and deserves the death penalty. Then mitigation means that there's some explanation here and why this person should not get the death penalty in this particular case. Those investigations are extremely costly. I think both prosecutors and defense lawyers sort of took advantage of that system. But then in a 12-year period, the state of Illinois taxpayers spent $160 million in providing these funds to investigate those cases, and during that period of time, we imposed only 15 death sentences. Now, that is pretty ridiculous on its face. So that was an important factor in abolition, although I think it was largely unspoken because the legislators who voted for it liked to posture that they were doing the right thing, that it was too late, that it was simply a risk that innocent people would be executed. That's why we're doing it. We're not really doing it because of, because it costs too much. But I think costs were an extremely important factor.
And why do they call it the Fort Heights 4 when there were really 5 victims?
Well, Initially, when the case started, we knew that Paula Gray was primarily a witness who had been convicted and who had indeed falsely confessed, but it was her testimony that led to the charges against against the four men, and it was that she recanted that testimony at some point, but then after two of the men won retrials, she recanted her recantation in exchange for a promise of leniency that the prosecutors were going to let her out of prison. They did, and then ultimately she finally recanted that. So when we started, when the case started, the focus was on the four men, and it's also perhaps ironic that at the time this case began, there was no Fort Heights. It was East Chicago Heights, and East Chicago Heights just had a terrible, terrible reputation, and at some point the village board voted to change the name to Fort Heights, and there was a big Ford plant nearby in Chicago Heights, Illinois, that's just a little bit to the west of East Chicago Heights, and they were hoping that that would somehow encourage employment or something and draw maybe investment into the suburbs or something if they linked it to the Ford plant. And so the board voted to change it to Fort Heights. But it's not only ironic that there were really five, but also that there was really no Fort Heights.
Do you think that this case has had an impact beyond Illinois?
Well, certainly certainly everything that happened in Illinois has had a big impact nationally in trying to abolish the death penalty, and I've been involved in working on abolition in New Jersey and California as well. So yes, to the extent that what happened in Illinois would not have happened absent Fort Heights and the power that Illinois abolition has had on the national movement. There are now 6 states that have legislatively abolished the death penalty. And there are now only, I think, 32 states with the death penalty, and many of those aren't really using it. So yes, it's indeed had a national impact.